like to welcome you all on this grey May morning to another Radcliffe Chambers Junior programme, this time on property, where you'll be hearing from myself, James Fagan, and Natalie Pratt. And I'm going to hand over now to Natalie, who will be speaking on the topic of service charges 101. So over to you, Natalie.
Yeah, so I'm going to be talking about residential service charges. So I'm going to be giving an overview and an introduction to the topic. The Q&A function is available, so you're used to all by now. It's at the bottom of the screen there. So please, if you have any questions, pop those in, and we will deal with all the questions, if there are any, at the end of James's talk as well. Okay, so residential service charges then. There are two things that I think leaseholders will complain of more often than not. The first of those is ground rent, and the second is service charge. And it is part and parcel of being a leaseholder that you have to pay service charge. Either you pay it directly to your landlord or you pay it to a management company or a managing agent. And usually the service charge is there to help fund the maintenance and the upkeep of the building and its communal areas, to ensure the building, and also to undertake bigger projects. So things like damp works, roof works, and perhaps things like the replacement of communal windows. And leaseholders will often complain either at the items of work that are being undertaken. They might say they're unnecessary, they're not needed, or often they'll complain about the cost of those works. And it's when those complaints arise and when tenants want to know if they're liable to pay these charges, that's often when we get involved. There we go. So my talk is going to cover 5 broad areas. So firstly, we're going to think about the contractual right to recover service charge. Secondly, we'll think about what is a service charge, what's the definition. Third and fourth, we'll look at the substantive requirements and then the formal requirements of service charge. I don't think that's a taxonomy that's used more widely in the literature in the case law. I think that's probably something that I've just fabricated for the purposes of today. And then fifth, we will have a think about resolving service charge disputes and some practical tips when doing those. So, turning first then to the contractual right for service charges. So the starting point in any service charge dispute, or indeed any question regarding service charge, should be the terms of the lease, because it's from the lease and it's from the lease terms that the obligation to pay any service charge will derive, and also the landlord's right to levy service charge will also derive from the terms of the lease. And when you are looking at those service charge provisions in the lease, the really important thing to remember is that the ordinary principles of contractual construction apply. And in particular, when you are looking at your service charge provisions, I think there are 3 things that you need to be alert to and on the lookout for. The first is whether service charge is payable either as a further rent or if it's just payable, simply under the deed. And we'll come back to this question later because it can be very important for limitation. And if you have a landlord who's trying to recover historic service charge, so if the service charge is recoverable as rent, there'll be a different limitation period to the limitation period that would apply if it's just recoverable under the deed. The second thing that you need to be on the lookout for when you are looking at your service charge provisions is whether the landlord has the right to demand service charge payments on account, so whether they have the right to make interim service charge demands. And that can be particularly important for landlords. Sorry about my emails popping up on the screen. And so this payment on account point can be very, very important for landlords, because if they don't have the right to demand payments on account, the consequence of that is that often they will have to front the cost for big projects and then seek to recover the cost from the tenants later on. And that can be really problematic for a landlord's cash flow. And so it's always worth keeping an eye on whether there is that right to make advanced demands and interim payment demands. It's also very important for a tenant to know whether that right exists in the lease as well, because ultimately it might turn out that a landlord is trying to seek payments at a time when really they're not entitled to do so. And the third thing to be on the lookout for when you are looking at your service charge provisions, I think, is to look at things that are expressly included and things that are expressly excluded from the definition of service charge, or costs that are recoverable and chargeable as service charge. So there may be some things that are expressly included, so you might not just be looking at replacement items or replacement works. It might be that the landlord is able to do improvements, and then on the flip side, those things might be expressly excluded. So your starting point, the headline here is the lease. Your ordinary principles of contractual construction apply, and you need to pay very careful attention to those terms. So that brings us to the question then of what is a service charge. I think probably most of us have a fairly intuitive feel as to what a service charge is. And actually, I think probably the legal definition on this occasion does largely match up to what our intuitive feel is. So the legal definitions at section 18 of the 1985 Act, I've extracted the provision here on the slide. To paraphrase, a service charge is an amount payable by a tenant, either as part of or in addition to their rent. It's payable for services, repairs, maintenance, improvement, insurance, or the landlord's management costs. And those costs and the charge will vary according to the cost of the repairs, maintenance, improvement, insurance, etc. So actually, probably the definition of service charge isn't too shocking, and it's probably what we were expecting to see. So that then brings us to the first of my taxonomies, that is the substantive requirements of service charge. So any cost that a landlord wants to pass on to a tenant by way of service charge must meet a reasonableness test. And that test is set out in section 19 of the 1985 Act. And again, I've put the relevant provision here on the slide. And as you can see, this test or this section distinguishes between incurred costs and advance payments of service charge. And so if you are in a situation where a cost has been incurred at the time that the demand for service charge is made, you have a two-stage test under section 19.1 that's going to apply. And that two-stage test is firstly that the costs must have been reasonably incurred, and secondly that any work or service provided must be of a reasonable standard. If, however, you're in a situation where the landlord is seeking an advance payment of service charge, they're making an interim demand for a payment on account, the test that applies is the one in section 19, subsection 2, and the test there is a one-stage test, and it is simply that the cost must be reasonable in amount. And what is reasonable in amount will be determined on a case-by-case basis by reference to the specific facts of your case. Now, it's usually, or disputes usually centre around this question of reasonableness, because ultimately, if a service charge or an item of service charge is unreasonable, then it can't be charged as service charge. So even if, in theory and in principle, it meets the definition of section 18, if the cost is unreasonable, the landlord cannot recover it against or from the tenant. So more often than not, your service charge disputes will turn on this question of reasonableness under section 19. And often when you start looking at the case law, you'll see that one of the issues that comes up quite frequently, and perhaps more so than all the others, is whether a cost has been reasonably incurred. So remember the test at section 19, subsection 1A. And I think there are four things that need flagging here when we're thinking about reasonably incurred. And these are particularly important because there is no statutory definition of reasonably incurred. So we need to look to the case law to work out what this actually means. And so the first thing that I think is worth flagging is that reasonably incurred is not a question of whether the sum is reasonable in amount, because remember that's the test at section 19 sub 2 for on account payments. Section 19.1a is worded differently, and I would say that quite deliberate, and it is there and it means something different. However, that said, if it can be shown that the charge is out of all proportion to the market rate, and there really is no justification for it being so out of proportion, then there's a reasonable chance that actually the cost has not been reasonably incurred. And I've put some cases on the slide if you want to have a look at them. The second point that I think is worth flagging is that a landlord doesn't necessarily need to pursue the cheapest option when they are fixing or remedying an issue at the property, provided what they're doing is a reasonable response to the issue or item that needs remedying, then the cost will be reasonably incurred. So they don't have to go for the cheapest option. So an example of this would be if a single glazed window was broken, the landlord could opt to replace that or elect to replace that with a double glazed window. Clearly, double glazing will be more expensive than the single glazing, but they don't have to pursue the cheapest option, and therefore double glazing window could still meet the test of reasonableness under section 19(1)(a). The cost could still be reasonably incurred. This, however, is where you really need to have regard to the terms of the lease, because it might be that the lease says only like-for-like replacements are permitted and chargeable to service charge, whereas double glazing, single glazing will clearly be an improvement. So you really must keep an eye on the terms of the lease in this respect. And also, it's the case that the landlord can't just replace things that don't need replacing or undertake items of maintenance that don't really need doing. So it must be reasonable in all circumstances. I've put on the slide here as well the Continental Property Ventures case. This case is particularly important because that case tells us that actually if the item of work to be carried out is covered either by a warranty or a guarantee or an insurance policy, then that warranty, guarantee or insurance policy should be utilised. And if the landlord then goes on and incurs the costs themselves, those costs will not be reasonably incurred and they can't be recovered from the tenant by way of service charge. The third thing that I've put here on the slide is that regard must be had to the fact that it is actually the tenants who will ultimately be paying these costs. And so therefore what is reasonable should be considered in the context of their financial means and not necessarily the landlord's financial means. And the final point on the bottom of the slide is one that I think is often overlooked, but is very important. Because to fall under the test in section 19(1), remember the costs must be reasonably incurred. So we don't just need to define reasonably, we need to also define incurred. And the case law tells us that a cost is incurred if the landlord has either received a demand for payment or if payment has in fact been made. And remember, if the cost isn't incurred, you're not in the test at section 19(1), you're down in the test in section 19(2). So you need to make sure you meet both the reasonably and incurred limit fall into section 19(1). Okay, so something that comes up quite often and a very common complaint of tenants is they say, well, look, actually the work has cost a lot more than it would have done had the landlord done this in a timely fashion. So had they done the works earlier, these works would have been a lot cheaper and therefore we shouldn't have to pay the elevated charge. So really, or usually what they're alleging here is that the landlord is in breach of a repairing covenant by some earlier inaction, and they seek to use this as a defence for the payment and recovery of service charge when the work is eventually done. An example that I've come across in practice, and I think a really good example of this argument, often arises in the context of damp works or dry rot works. So I had a case where the landlord ignored the early signs of damp and dry rot. They ignored the tenant's reports that there was leaking guttering, leaking downpipes and standing water in the basement of the property. The dry rot and damp problem got a lot worse over time. And then ultimately the tenants say, well, look, the fix at the end of the day was a hell of a lot more expensive than it needed to be. It would have been much cheaper had you acted when we first reported to you that there was an issue. And the question that the tenants want to know is, can we rely on that breach of covenant as a defence to the payment of the service charge? There are two important cases that deal with this point, and they're up there on the slide. One that I keep citing, the Continental Property Ventures case, but also the Dejan Properties and Gifting case has a lot to say in this regard as well. And there are 2 points really that these cases, or 2 things that these cases tell us. The first is that historic neglect, whether or not that amounts to a breach of covenant, does not speak to the question of whether the costs have been reasonably incurred. So actually, if at the time the work was done, it needed to be done, then the costs were reasonably incurred. doesn't matter that they were more expensive than they otherwise would have been had the landlord acted earlier. And to borrow the metaphor from the Continental Property Ventures case, in that case, the discussion is, well, look, if the work was done at the first possible opportunity, you only needed 1 stitch in the wound. When the work was in fact done, we needed 10 stitches in the wound. Can the landlord recover all 10 stitches or the cost of all 10 stitches? And the answer to that is yes. At the time that they elected to do the work, 10 stitches was in fact reasonable, and therefore they can recover the costs of that. The second thing that these cases tell us, though, is don't worry, the tenants aren't completely without a remedy in these circumstances. If you can show that there's been a breach of covenant, and you can show that that breach of covenant has caused the work to be more expensive when it was eventually done, then a remedy in damages may follow. And the quantification of those damages will be, or could be, the elevated cost of the works. And there are 2 ways you could do this. You could either run this as its own breach of covenant claim, or probably more likely, you would run it as a counterclaim in the recovery of service charge action. So that brings me then to the formal requirements when it comes to service charge. I think it's fair to say that there are lots of formality requirements that you need to be aware of when it comes to service charges, and actually they can be a bit of a procedural minefield. But I think there are probably 2 formality requirements in particular of which you need to be aware for purposes of a Service Charge 101 overview. And those are, firstly, the consulting requirements, and secondly, the requirements surrounding, or the formality requirements surrounding service charge demands. Thinking about consultation, the 2 key pieces of legislation of which you need to be aware are the Landlord and Tenant Act 1985, Section 20 and Section 20 ZA, and then the mouthful that is the Service Charges Consultation Requirements England Regulations 2003. So we'll just call them the 2003 regulations, much simpler. In terms of consultation then, Section 20 of the 1985 Act tells us that leaseholders must be consulted on qualifying works or qualifying long-term agreements. And those things are defined in the 2003 regulations, and qualifying works are defined as works where each leaseholder's contribution would be over £250, and qualifying long-term agreements are defined as agreements where each leaseholder's contribution would be over £100 in any 12-month accounting period. Now, it's really important to keep an eye on whether your client needs to consult, because if the duty to consult does arise and yet the landlord fails to consult, then actually the landlord is limited in the costs that they can charge to service charge. They're limited in what they can recover for each item of expenditure. So if it's a qualifying work, they're limited to recovering only £250. And if it's a qualifying long-term agreement, they are limited to recovering only the £100. So it's very important to keep an eye on if your client needs to consult, and if they do, making sure that you engage in and do that consultation properly. Thinking about the procedure then, the procedure for the service of the Section 20 notice and all the things that follow thereafter is set out in the schedules to the 2003 regulations. I'm not going to go through them today. I'm not sure there's too much value in doing that, because it's the sort of thing that you would have to go back to every time just to make sure that you're getting it spot on, getting it absolutely right. And finally then, on consultation, a landlord can apply to the first tier tribunal for dispensation from the consultation requirements. It can either seek that dispensation prospectively or retrospectively, and equally the FTT can grant the dispensation either conditionally or unconditionally. Usually, if a landlord is seeking a retrospective dispensation, that's because there was just simply no time to make the application prior to the works being undertaken. So they were probably emergency works, for example. Under Section 20 ZA then, the tribunal can grant the dispensation if it considers that it is reasonable to do so, so another test of reasonableness. But in determining reasonableness, the primary consideration is whether the tenants have been prejudiced by the absence of any consultation, because ultimately the consultation requirements are there to protect leaseholders. The formalities surrounding service charge demands then, there's a lot to get right. And it really isn't just as simple as sending a tenant a bill or an invoice. There are four that I think I should flag for the purposes of a broad overview of the topic. The first is Section 48 of the 1987 Landlord and Tenant Act. So a landlord must provide the tenant with an address for service of notices before making any service charge demand. And if they haven't provided that address, then any sums will not be treated as due for the purpose of service charge. So really here, the best practice is to include an address for service in the lease, and that way you would be meeting that requirement. The Section 47 of the 1987 Act is also very important. So a service charge demand must contain both the name and address of the landlord. Again, if it doesn't do that, then the sums are not treated as being due and owing. Then dropping back into the 1985 Act, Section 21B, service charge demands must be accompanied by a summary of the tenant's rights and obligations in relation to service charge. And until that summary is provided, a tenant may withhold their service charge. And if they do withhold it, if they do elect to withhold that service charge, they're not liable for that non-payment or any breach of the lease. And finally, and one that landlords really need to keep an eye on, is Section 20B of the 1985 Act. So service charge demands have to be served within 18 months of the costs being incurred, or at the very least, you need to serve a notice saying that a cost has been incurred and the tenant will be required to pay it. And if you miss your 18-month deadline, then the consequence of that is that a landlord can't recover that charge or that cost as service charge. So you really need to keep an eye on the time, and you need to make sure that you're within the 18 months and that you're serving your notices and your demands appropriately. Okay, so that brings us to the final portion of the talk then, some top tips or some practical tips for resolving service charge disputes. So service charge disputes, as we've mentioned, are usually about whether service charges are payable and if they're payable in what quantity or what quantification of charge. And usually they centre around the question of reasonableness. So we're usually looking at Section 19 reasonableness challenge. Service charge disputes are subject to the jurisdiction of the first tier tribunal property chamber. We know that because the Landlord and Tenant Act 1985, Section 27A, tells us that that is where these disputes belong. If you are a landlord who is looking to recover unpaid service charge, or indeed if you're a tenant who is looking to avoid paying historic service charge, you want to keep an eye on the relevant limitation periods. I mentioned this earlier. If your service charge is recoverable as rent, then the limitation period is 6 years. So that's Section 19 of the Limitation Act 1980. If, however, the service charge is payable simply under the deed, then the limitation period is 12 years. Whether a service charge is payable as rent or is just simply payable under the deed is a question of construction. And remember, construction according to the ordinary principles of contractual construction. But often you'll see clauses that say things like a service charge is payable by way of rent or further rent. So then that would tell you that it was a 6-year limitation period that you're dealing with. So said that service charge disputes majoritively belong in the first tier tribunal, and that has two important cost consequences of which you need to be aware. The first is that we would probably describe the cost regime in the tribunal as being cost neutral, because the tribunal will not make an order for costs unless one party has behaved unreasonably in bringing, conducting, or defending the proceedings. And so that's Rule 13 of the tribunal procedure rules. That doesn't stop the tribunal from making an award to reimburse for the payment of tribunal fees, but it does prevent them from making an order for costs unless there has been unreasonable behaviour. So here, I think the point is that it's really worth keeping an eye on the proportionality of your cases and the costs that are being incurred, and really, what's at stake, because you're not going to get your costs back. The other very important point when it comes to costs in the tribunal is that if you are a tenant, you should always consider making an application under Section 20C of the Landlord and Tenant Act 1985. So an application under 20C is an application for an order that prevents the landlord from recovering their costs of the proceedings from the tenants by way of service charge. So really, the landlords do have an option to try and get their costs through the back door by charging it to service charge. And so tenants have the option to apply for an order under Section 20C to prevent the landlords from doing that. So if you are acting for a tenant, that's always worth thinking about. And those applications can be very, very useful for tenants. A landlord can issue proceedings in the county courts to recover unpaid service charge. Ultimately, these are sums that are payable under a contract, and if they are not paid, then that has all the flavour of a simple debt claim. However, just be aware, if the tenant then defends it or defends your claim on the basis that charges are not due and owing because they're not reasonable, for example, then the matter falls within the jurisdiction of the FTT, and the matter does need to be transferred back to or over to the FTT for determination as to what is due and payable with regard to reasonableness. If you are in a situation where you have a case being bumped over from the county court to the FTT, I suppose one of two things could happen. The first is the county court proceedings could be stayed. The FTT can then decide whether charges are due and payable and the amount that's due and payable. And then if necessary, you can go back to the county court and seek to recover the sum through your debt claim. The other option is that, and perhaps in some situations this would be ideal as well, you can have a double hatting situation. So you can have a situation where a judge sits both as an FTT judge and as a county court judge, and that way you can get your determination as to whether service charge is due and payable, and then you can get your county court order at the same time. If you are doing that, you just need to be very careful, but both you and the judge need to be very careful that decisions are being made under the correct jurisdiction and through the correct processes. So for example, if you're asking the judge to do something with their county court hat on, they need to be very careful not to talk to the other members of the tribunal panel about that decision, because it's simply a decision for them to make in their capacity as a county court judge. The other things to keep an eye on with the double hatting is the cost regime, because remember, the FTT is cost neutral. Depending on which track you're allocated to the county court, that is not cost neutral. So that's worth keeping an eye on as well. So to complete the picture on costs, we probably also need to flag the position where you have a contractual cost provision in the lease. So it's very common for leases to have a clause that allows the landlord to recover costs that are incurred either in forfeiture proceedings or in contemplation of forfeiture proceedings, so under Section 146 of the LPA. And this overlaps with service charge because under the Housing Act, a landlord can't forfeit a lease under Section 146 of the LPA for non-payment of service charge without first obtaining a determination that that charge is in fact due and payable. So if you want to forfeit for non-payment of service charge, you have to first go to the FTT and get a determination that actually these charges are due and payable, and only then can you go on to do your Section 146 forfeiture. And where the FTT determination is sought in the context of forfeiture proceedings, so either as part of wider proceedings or at least in contemplation of, the case law tells us that actually you can recover the costs under these contractual provisions, and you can do that through the county court. And the case that you need to be aware of is the freeholders of 69 Marina case. So it's worth keeping an eye on that as well. If there is such a contractual provision relating to forfeiture, and the landlord is seeking that determination in order to then make a forfeiture application, just be aware that actually there is a backdoor through which costs could be awarded against the tenant. Okay, that then brings me to the very last thing that I'm going to say before I hand over to James. I think the reality of many service charge disputes is that they're not actually just one-off events. And they are often either symptomatic of or signal a wider breakdown in the relationship between the landlord and the tenant. And so that really begs the question of what can we do in the longer term to prevent all these issues arising again, and ultimately putting everyone to the inconvenience and expense of litigation. And you do have the more drastic options of either forming a right to manage company or perhaps the acquisition of the freehold of the property by the tenants. But ultimately, those things are going to require quite a heavy investment, both in terms of time and expenditure. So perhaps more manageable option might be to seek the appointment of a property manager, and you can do this under the 1987 Act under Section 24. And so the manager undertakes the management functions, and they can also undertake the role of a receiver if they're appointed to do that. And so it'll be they who are responsible for the maintenance and the upkeep of the building and the levying of service charge to fund those things. And what's really useful here is that the tenants can propose the identity of the manager. They can put people forward. Now, ultimately, the FTT have to be satisfied that this person's a fit and proper person to be a property manager before they make the appointment. But actually, taking the management of the property out of the landlord's hands, or at least out of the hands of the person that the landlord has appointed to be a manager and on whose watch all of these issues has arisen, that can actually be quite a powerful and useful tool in remedying these disputes, and it can be quite effective. And so it gives an opportunity to ensure that the property is being managed in accordance with all of the statutory requirements, but also at a cost that is acceptable to the tenants. So I think that is me, and that is Service Charge 101.
Thank you very much. Thank you to those of you who have stuck around for this, my talk on residential repossessions, practical refresher. This is intended as a practical talk focusing primarily on the recovery of rental properties by landlords. Possession of property subject to mortgages and possession of properties in cases of trespass will fall outside the scope of today's talk. However, I would hope that some of the tips I'm going to share would be equally applicable in those situations. And due to the impact of devolution and how the housing legislation works in the United Kingdom, this talk will only focus on the law as it applies to England, or else we might get a little bit too confused trying to continually draw distinctions between England and Wales, because there are alternative timetables and requirements when dealing with Welsh leasehold properties. The purpose of this talk is to cover some key basics. It's not intended to be exhaustive. Some of you may have joined your firms since the pandemic began, and have not seen much in the way of possession proceedings. So my intention today is to share some key items I think you should think about and practical steps that can help any possession proceedings run smoothly and get you the order that you're seeking. So without further ado, let's get started. In terms of routes to possession and repossessing leasehold properties that are rented out, there's generally two routes that are taken under the Housing Act 1988. And Section 21 notice is generally considered the no-fault route to evictions. A Section 21 notice validly served will result in a possession order being made if the tenants do not leave the property, and obviously can then be enforced through the usual means. However, there are a variety of legal requirements that must be adhered to by a landlord before he can obtain a possession order under the Section 21 route. The other option is to use a Section 8 notice. This is a fault-based or grounds-based route to evict a tenant and obtain possession of a let property. There are a variety of grounds which, if proven, entitle the court to make an order for possession under Section 8. Some of the grounds are mandatory, insofar as if you can establish them, if the requirements are met, the court must make the order for possession. Some grounds, however, are discretionary. So even if you can show that there is some persistent delay in paying rent or something like that, under some of the grounds, you may not get the order if the judge doesn't think it's just and reasonable. If you're looking for a list of the grounds, they can be found as Schedule 2 to the Housing Act 1988. The most common one that tends to be relied on is Ground 8, which is arrears outstanding in the amount of 2 months at the time the notice is served, and still outstanding at least 2 months of arrears of rent at the time the hearing comes to be determined. So let's move on to our first practical set of tips. So pre-action matters. Let's deal with a Section 21 notice. As I said, the Section 21 notice procedure is subject to a number of procedural steps insofar as if the landlord hasn't adhered to legislative requirements in renting out the property, then he will be prevented from seeking possession under Section 21. So the first of these is under the Housing Act 2004, which essentially says if you do not protect a deposit in the proper way, a Section 21 notice cannot be validly served. So the first thing to check is if a client wants to seek possession under this route is whether or not they've actually protected their tenant's deposit. The second act which imposes restrictions is the Deregulation Act of 2015. From 1st of October 2018, the provisions of this act apply to all assured short-hold tenancies whenever they were granted. There is a limited exception for tenancies that were granted before that act came into place. But in practice, I recommend not trying to make that distinction. It only relates to the provision of certain information. And it's just easier to make sure that information is given before a notice is issued to the tenant. So what type of steps does this act require? Well, first, there is a prescribed form of notice under Section 37. So you want to make sure that whatever notice is going to be served adheres to what are the current requirements for what must be in it. Second, the Deregulation Act protects tenants from retaliatory evictions, so where legitimate complaints are raised. So if a tenant notifies the landlord that there is a complaint relating to the property, the landlord has time to respond and address this. The tenant can then refer the matter to a local housing authority who can serve a notice for remediation of certain health and safety issues. That local housing authority notice will invalidate any Section 21 notice that has been served after a complaint has been raised. There are limited exceptions relating to sale of the property if the landlord is a housing association and a mortgagee exercising a power of sale. But it's important to ensure that when you ask your client whether there's been any complaints made relating to the state of the property, because that could cause issues down the line and cause the notice to be invalid. The third point to note is that a Section 21 notice cannot be given within the first months of a contractual fixed term tenancy. The idea here is you can't seek eviction within the first 6 months of a tenancy using the Section 21 procedure, at least under the old rules relating to time periods, because you would normally then have 2 months notice period, which obviously, as we'll get on to later, has been extended due to the coronavirus pandemic. The fourth restriction to be aware of is that the landlord must provide the tenant with certain prescribed information, and you cannot serve a Section 21 notice until that information has been provided. So what is that information? It's things like an EPC certificate, a gas safety certificate, and the prescribed information about rights and responsibilities of a landlord and a tenant that exist in the Ministry of Housing Guide, How to Rent, the checklist for renting in England. That's Section 39 of the Deregulation Act requires that. So it's always good to check, has this information been provided? And if not, make sure it's provided before a notice is served. And then fifthly, under the Tenant Fees Act 2019, a landlord must only receive permitted payments. Permitted payments are listed in the Schedule 1 to the Tenant Fees Act. And generally they relate to the size of the deposit, the amount of rent, so you can't require more than a certain number of weeks deposit or certain extra rent payments at the start of a tenancy, or letting agent fees at the beginning or the renewal of a tenancy. And if those payments have been made, until such time that they've actually been repaid, you can't issue a Section 21 notice. So once you've checked all these materials, and hopefully your landlord client is in compliance, I recommend you make a written note on the file as to the dates which all that information has been provided, or confirmations that there hasn't been any prohibited payments and that the tenancy has been properly protected. Because then, when you come to issuing proceedings and filling in the information, there won't be any questions about whether those sort of pre-action matters have been adhered to in relation to a Section 21 notice. In terms of Section 8, unsurprisingly, because it's already based on evidential grounds for seeking possession, there's not as much in the way of sort of pre-action matters that need to be adhered to in the same way as the no fault Section 21 notice. Grounds 1 to 5 specifically require a landlord to have given a written notice before the tenancy is entered that the landlord may wish to regain possession of the property under one of those grounds. So they relate to repossession under mortgages, repossession because the landlord wishes to live in the property. But the grounds themselves specifically state that written notice must have been given prior, at least prior to tenancy or at the beginning of it. So if you're instructed to seek possession on those grounds, you need to just double check that the correct notice has been given. More recently, in fact, as recently as last week, there is the new debt respite scheme, breathing space moratorium and mental health crisis moratorium regulations. This is a new form of debt relief and respite for debtors in England and Wales. Specifically, it allows the creation of a moratorium on moratorium debts, which essentially are qualifying debts in existence at the time a moratorium is imposed. The regulations only came into force last week. The specific focus of them is that the moratorium can be created where, following attending a debt advice service, certain requirements are met. That debt advisor can file a notice with the insolvency service, which will create a breathing space moratorium, which lasts for up to 60 days. Alternatively, in situations where a debtor is experiencing a mental health crisis, certain medical professionals or other named persons can issue a notice to the insolvency service for a mental health crisis breathing space moratorium, which continues for the length of the mental health crisis treatment plus 30 days. And the big impact for landlords under these regulations is that it specifically seeks to prevent a landlord from serving Section 8 notice on grounds 8, 10 or 11, which are the rent arrears notices, in relation to any rent that falls within the definition of a moratorium debt. So that's under Regulation 7 of those regulations. This means that rent that was due and owing at the time the tenant applied for a moratorium will effectively be subject to that moratorium. There can't be any action in relation to it. A landlord who has served a Section 8 notice on any of these grounds before the proceedings has started will be unable to commence proceedings for the duration of the Section 8, for the duration of the moratorium, or where there are proceedings already in motion, already commenced. There is an obligation on the landlord to inform the court of the moratorium, and the court will then likely stay those proceedings or issue such directions in relation to that moratorium. So that is a new sort of debt relief scheme that's only just come into force in the past week, and it's something that all landlords should bear in mind and ensure they have adequate systems in place that if they receive notification that a debt respite scheme moratorium has come into force in relation to one of their tenants, they know their rights and obligations in relation to it. So you've prepared your notice and now you need to serve it. Well, there's a few things you're going to need to check before that happens. The first thing is the form of your notice up to date? As you will recall, I've told you that a Section 21 notice must be in the prescribed form, as must a Section 8 notice, in terms of giving the requisite information, the date it's served, the date on which proceedings can be commenced, things like that. In particular, I note that the official Section 8 notice available from the government website has already been updated to include details of that debt respite scheme, breathing space moratorium, mental health crisis moratorium. So you'll want to check that you have the correct, most recently published form of notice. That'll stop any questions being raised further down the line. You need to make sure that you've filled in the information properly. It often happens that you find that notices served leave out important information, such as the date on which the notice is made, the date on which proceedings can be brought, and the date by which proceedings have to be brought. The other thing you need to check is how is it going to be served. So obviously you can serve it through the post box, you can serve it by mail, but you want to check the underlying agreement, the tenancy agreement, because you want to make sure that if there's a required means of serving notices between the landlord and the tenant, that you are also serving in that manner. It's best to cover all your bases here, because you just want to try and avoid arguments further down the line that there was a prescribed means of serving a notice and you haven't adhered to that. And then to make things even easier, fill out a certificate of service, Form N2115. Sometimes you get to these hearings and questions arise because the defendant turns up and says, well, I was never actually served this. Well, if you've got a certificate of service verified by statement of truth that briefly says how, when, where the notice was given, well, that's going to take the legs out of most of those arguments, and you'll just be in a better, more comfortable position by the time you come to get your order. And those forms are very straightforward. You can just fill in the fields, sign them, date them, and put them on the file. Serve them with the proceedings when you issue a court. It'll make your life a lot easier. So you've served your notice, you want to now issue proceedings. The first thing you need to ask yourself is, has the notice period elapsed? So whenever you serve a notice under Section 21 or Section 8, there is a minimum period that must pass before you're allowed as a landlord to commence proceedings. A lot of this has changed in the past year in light of the coronavirus pandemic. Under Section 21, the notice period used to be 2 months. It then increased to 3 months during the summer for notices served 28th of March to 26th of March to 28th of August of last year. And then notices on or after the 29th of August are 6 months. Similarly, Section 8 notices, the notice period will vary in relation to the ground that's stated in the notice. Unlike Section 21, there isn't a overall notice period that has to be adhered to. But it's important to bear in mind the shortest notice periods. So ground 7A, antisocial behaviour, serious antisocial behaviour, is 4 weeks. For rent arrears under grounds 8, 10 or 11, it's 6 months if the rent due is less than 6 months in arrears, or it's 4 weeks if there's 6 months or more outstanding. And finally, in relation to a tenancy given because of a false statement, it's a 2-week notice. However, as of yesterday, the government has announced they're going to change the notices again, which will be good news to a lot of landlords. The Housing Minister, Christopher Pincher, announced that they're going to follow a phased approach to reducing the notice periods for eviction notices. So from the 1st of June, the 6 months will be reduced to 4 months, which is obviously good news because it's shorter. The intention is that, subject to the government's roadmap for easing restrictions and obviously the situation in relation to the coronavirus and these variants that are out there. The intention is that on the 1st of October, we will return to the pre-pandemic notice periods, so the 2 months under Section 21. And it's important to note, as I said, that while there's shorter notice for those arrears in excess of 6 months, from the 1st of August, it appears that the government is going to permit a 4-month notice period for arrears that are 4 months or greater. So you won't have to rely on that 6-month notice period. So it's just important to bear that in mind. Keep an eye on the government website, the Ministry of Housing website for updates. But those are the proposed changes that were announced yesterday afternoon. So you've checked your notice. The notice period has elapsed. You now need to issue your claim. So you need to fill out your claim form. Check CPR Part 55 and Practice Direction 55A, which are the relevant practice parts of CPR which apply to possession proceedings. Complete your claim form. Ensure that you've ticked the appropriate boxes. You've identified the type of notice you relied on. If using Section 8 grounds, the ground which you're seeking possession on, and include accurate details as to monthly rent, the day it falls due, a clear statement of the daily rate of rent, because that will be important to claiming mean profits if the tenant stays in following an eviction note, following a possession order after the time that which they're given to leave. The landlord can claim on the daily rate for additional unpaid rent. Unfortunately, it happens that I find sometimes people don't put that information in a claim form, or if they do, they don't put it out. They don't set it out clearly. They add numbers together. The daily rate is inclusive of interest and rent. It's important to try and just break everything down clearly, because when you get to a hearing, it's very easy for it just not to be clear what's due and when, and that can just result in errors being made by the court when drawing up the order. That will result in a lower recovery for the client, which is just something you want to avoid. You would also want to consider including any other forms of relief. So, for example, if there's a mandated interest rate on late payments of rent in the contract, you'll want to include details of that clearly in the claim form, and also how much that's accruing on a daily basis. You'll also want to consider whether the landlord wishes to retain and use any deposit against arrears of rent. I have heard from some clients that in the past, the Deposit Protection Service has refused to release the deposit to a landlord so that it can be applied to rent arrears following a possession order. So provided the tenancy agreement provides for it, you could ask that this be included in any order for possession so that it can be handed to the Tenancy Deposit Service to allow basically ease the recovery of that deposit for the benefit of the landlord. You need to then ask yourself, is the notice still valid? Under Section 21, there is a time limit for when you can commence the proceedings. It's under the Coronavirus Act, it is currently 10 months. Previously, it was 6 months from the date of service of the notice. And it's something that can easily be gotten wrong if there's a delay, if someone's been sitting on it. Because if you've run out of time, you're going to have to restart the process. In relation to Section 8, it's a little bit clearer. It's just simply 12 months from the date of issue. You should also need, going back to Section 21, in certain circumstances, the date required to be specified in the Section 21 notice is meant to be 2 months after the date when the notice is served. So this is under subsection 4, 21.4b and 21.4e, which relates generally to notices to quit and sort of how the timelines work on that. But in those circumstances, the time for commencement is no later than 4 months from the date set in the notice. So you just want to check that because it can be quite embarrassing to have to then report back to your client that unfortunately we haven't served in time. You need to restart the process. When it comes to filing at court, just don't leave it close to the expiration date to issue proceedings. It can happen that a claim form sent to the court can be left for days to be looked at before the court office issues it. It can then lead to a certain situation where you walk into court, you ask for your order to be made, and the court says, "I'm sorry, the claim was issued out of time," even though you've sent it to the court. It's from the date of issue that the court's going to be looked at, not the date at which it's received. And there is case law to that effect, certainly in relation to social housing, that most likely applies in the private rental sector as well. So what should you do? Well, honestly, the gold standard is to go in person, hand it over and see it get stamped in front of you then and there and leave with a copy. Obviously, that's difficult at the moment. So just trying to get it into court well in advance is the good thing. But once we go back to normal service and once the courts are open a bit more again, I just would caution against thinking that postal route is safe and easy. Just go that extra step. You just don't want to have a situation where, again, there's been an issuing out of time. And the final point I'd note is that if you are going to claim against trespassers, so sometimes the landlord thinks that there's people in the property who he wants to be able to get out that are effect trespassing, as well as the tenants. And so sometimes you'll want to issue a claim against persons unknown. You need to be very careful if you do that, because there are prescribed methods of serving on persons unknown under the CPR in Rule 55.6, specifically in relation to how the notice is displayed at the property on any doors or gates, put through the mailbox, or affixed on posts on the land. So I would advise, if you are going to serve against persons unknown in a repossession case, you will need to just familiarize yourself with those provisions and potentially use the services of an experienced process server so that everything is recorded and able to be submitted to court later on. So you filed everything, you served everything, your hearing's coming up. What next? Well, if you served a Section 21 notice, hopefully all you're going to need to do then is turn up and get the order. However, if you are claiming arrears or making a Section 8 claim, you'll need to consider your evidence of the ground. Hopefully all the information you need has been put in the statement of case, but sometimes you might want to update that. And so sometimes a short witness statement might be useful, particularly if your claim has been stayed by the coronavirus pandemic for quite some time. It might be helpful to update the court file with a witness statement, just going through the various requirements that need to be met, updating the court as to rent arrears and as to the level of interest that would fall to be charged on the hearing date. If you are going to submit schedules of this, make sure they're correctly formatted and readable. Too often people use colors on Excel or PDFs that when they get printed monochrome, because the printers in the courts are only black and white, they're illegible, and that causes difficulty, particularly if there isn't a clear statement in the particulars of claim breaking down the individual figures and totals by date and month and day. And then finally, you need to consider your PD55C notices. In particular, paragraph 6 requires a notice to be filed at court in advance of the hearing about whether there's any knowledge of the effect of the coronavirus pandemic on the tenants and their dependents. That PD55C is going to last at least until 31st of July. It's an open question whether that will remain following the roadmap out of coronavirus restrictions. Another point to be aware of is there is continually judicial pushback on costs in possession proceedings. While contractual entitlements to cost exist, they are subject to the rule in CPR Rule 44.5 that those costs must be reasonable and proportionate. I have had a number of cases where costs are being claimed by solicitors acting for landlords that are being summarily assessed and reduced by up to 66% because they are undefended possession proceedings. It's a constant line from the judiciary in the county courts that the costs are running up too high. So I recommend making full use of paralegals, trainees and juniors to do the drafting of notices, the drafting of witness statements and particulars, and having them then checked by senior members in the firm. It's worth considering creating precedents and checklists within your firm to speed up the process and help keep costs low in order to avoid just the difficulty of trying to justify high costs. Now, obviously, if it's a complex case, they can be justified, but a lot of these possession proceedings ultimately are undefended. And so judges tend to view the costs need to be a lot more proportionate in those circumstances. Finally, and I'm appreciating we're running late, enforcement. So under CPR Part 83, you'll find the rules for enforcing a possession order if you obtain one. If you're in the county court, that's a warrant of possession. If it's the High Court, a writ of possession. And if you're looking to distrain on the goods of a tenant because you've received a money judgment, that's a writ of control. The persons who can carry out your enforcement are county court bailiffs or High Court enforcement officers. You must adhere to the rule in CPR 83.8a, which is that a notice of eviction must be delivered not less than 14 days before a writ or warrant of possession is executed. If you don't do that, you will not be able to enforce. Currently, there is a stay on enforcement. That stay runs until the 31st of this month. There are limited exemptions. It's worth checking if you've had any possession orders made in the past 6 months to 8 months, whether there's in fact, it states the grounds, and then you can check the grounds in the Public Health Protection from Eviction Amendment regulations to see whether you come in. Arrears in excess of 6 months is an exception. But good news, as part of the announcement yesterday, there is no indication that they're going to renew this stay on enforcement. So from mid-June, we will likely see enforcements running again. So I think we have a few Q&As.
And if we don't get to answer anyone's questions, I realise people are sort of dropping off. You've probably got stuff to do. Haven't consulted James on this, but please do feel free to email us your questions. We will answer them if we don't get to answer them now. James is nodding, so he either agrees or he's been bullied into it by me, one or the other. Okay, service charges very quickly then. There were 2 questions. First question was preemptive, asked whether it's ever appropriate to withhold service charge, or is it always recommended that you pay and then seek to recover it back from the landlord? So hopefully I touched on that a little bit when we looked at section 21B of the 1985 Act, so a circumstance in which a tenant can withhold the payment of service charge. So if you haven't had, or if you haven't served that summary of the tenant's obligations and rights in relation to service charge, in those circumstances, it's perfectly proper to withhold. The other thing to flag on this part as well is that section 27A, subsection 5 of the LTA 1985 tells us that actually if the tenant does pay, then that's not taken as being an admission that the sum was in fact due and payable. It doesn't prejudice you then having a go at the reasonableness of the service charge in the FTT. So if in doubt, I suppose I would say, it depends on the circumstances of the case, but if in doubt, pay it because it doesn't prejudice the dispute. And ultimately, if you don't pay it and then you turn out to have been in the wrong, you might find yourself or your client subject to late payment charges and also interest. And the second question for me was what happens if the service charge really only relates to one of a number of leaseholders in the building, but in any event is over the £250 threshold? Is that something for which consultation is required? I would suggest yes. If it's going to be more than £250, then the statute would say that consultation is required. If for whatever reason you think that is unnecessary, then of course you can always apply to the tribunal for dispensation. And the final part of that question for me is also what happens if you use a contractor habitually, but not on a qualifying long-term agreement. Are you then limited to your £100 recovery? I would say probably not on the basis of the qualifying long-term agreement, but if you are habitually using a contractor, it suggests that you're probably undertaking fairly significant works, and you might find that actually you are having to consult on the qualifying works criteria instead. I think if in doubt, consult. If you don't want to consult, then seek dispensation. So over to James.
Yes, I'll try and get through these quickly. So if, in respect to work so extensive, it would be better for the tenant to vacate the premises, but the tenant refuses to leave. Could you still rely on a Section 21, or would this be considered retaliatory? Would you do this and serve it without prejudice Section 8 notice just in case? I think in that situation, I would avoid using the Section 21 process. It's fairly clear that the trigger is if a Section 21 notice is issued when a local housing authority notice has been served in respect to remediation works. Obviously, the tenant refuses to leave, you might be able to establish Section 8 grounds and proceed on that basis. Obviously, that would require evidence. I think that would just that's a situation that requires careful consideration. Can a landlord make inquiries as to whether a tenant has breathing space, or should they wait to receive notification? If the assuming this is the debt breathing space, I think what would normally happen is that debtors will have to be listed in the notice that's given to the insolvency service. So the landlord should receive notification of the breathing space. There's obviously no difficulties I foresee in asking a tenant whether they have breathing space, but I think you can proceed on the basis they don't until you receive the notification. If a tenant refuses to formally leave the property after the repossession date passes, retaining the key, but if they vacated the property, is there any other way to enforce possession other than instructing a High Court enforcement officer? I think in those circumstances, if you've made enough inquiries and it appears they have left and they just simply haven't left you the key, it's likely that you can then just enter the property yourself without necessarily instructing enforcement officers. But obviously, you should fully check whether they've left the property and have left it vacant before you do that, because the order is always for vacant possession. Then the next question is in relation to the changes announced yesterday regarding notice periods for Section 21 notices. On the 1st of June, could a landlord serve a second Section 21 notice terminating the lease earlier, having already given a notice giving 6-month notice prior to 1st of June? We don't know exactly what the means in which they're going to put this into law, but you can always cancel a notice and serve another notice if that's going to speed things up. I think there's nothing from my reading that would necessarily stop that. I think you just need to familiarize yourself with the upcoming changes to the law once they're published and put through. I think that answers everything.
I think we're done. Yeah.
So with that, I think we can say goodbye. Thank you all for attending.
Thank you.